After news broke that the man charged in the Waukesha Christmas parade tragedy, Darrell Brooks, had been out of jail on a $1,000 bail, calls for reform to the state's bail system have followed.
The I-Team takes a look at what bail is in the state of Wisconsin and if it needs to change. Here's Sean Gallagher.
In the state of Wisconsin, bail is meant to ensure someone shows back up to court, kind of like a security deposit. We spoke to experts on multiple sides of the court system about whether the law was properly followed in the Brooks case and if that law needs to change.
It's a good time for us to back up and reflect and say, how can we ensure this doesn't repeat itself?
We asked former Supreme Court Justice and current Marquette Law School professor JANINE GESKE what the decision-making process is like setting bail in a case like Darrell Brooks's.
And the idea of bail is not to say, well, you've been caught for one, so we're going to lock you up now so you can't go commit others. That's not the way our Constitution works.
She says there's always pressure because a person is presumed innocent at that point in the legal process.
When you set $100 bail on somebody, he or she may not be able to post that money. They may actually sit in jail for 90 days or 120 days waiting for trial. Even if they're acquitted down the road, nobody pays them back for that time.
Milwaukee County District Attorney John Chisholm says despite the cash bail being set inappropriately low in the Brooks case, he's actually in favor of getting rid of cash bail in Wisconsin altogether.
While this is unquestionably a tragedy, I don't think that the right thing to do is to further restrict others who have not committed these very serious crimes, but who are accused and presumed innocent.
Kate Judson is the executive director for the Center for Integrity and Forensic Science, a group aimed at researching and promoting data-based solutions in the criminal justice system. She says cash bail can disproportionately affect communities of color and those who are impoverished, not to mention the cost to the system.
Across the country, American taxpayers pay $14 billion to hold people who are presumed innocent, people prior to trial. And that's just not a good system.
Judson says there is evidence posting cash bail doesn't necessarily improve a defendant's likelihood of appearing in court. She points to data from the Bail Project, a group that posted bail for more than 1,200 people in Cook County, Illinois. 96% of that group returned to court, according to the Bail Project's annual report. Judson notes there are times when holding a person would be appropriate, but on a case-by-case basis. According to the State Department of Justice, in 2018, the most recent year where data is available, there were nearly 22,000 domestic abuse cases in the state of Wisconsin.
If what we're suggesting is that the right thing to do is to hold over 20,000 people in jails and prisons until their day in court, even though they're presumed innocent, I mean, that's deeply problematic. It's expensive and it's unjust.
There's not a system where you try to set a dollar amount at a certain level and have to ultimately hope that somebody who you think is dangerous can't raise that amount of money to pay for bail.
The I-Team asked the state attorney general, Josh Kaul, about bail in Wisconsin. He pointed to his time as a federal prosecutor, saying lawmakers should consider revising the pretrial release system to something more closely resembling federal detention hearings. In federal court, a person requests bail, and it's determined at a detention hearing what to do with the defendant. If they are granted bail, in some cases, the defendant will sign what's called a surety bond with another person, sometimes a family member or friend, to help ensure their return to court. Kaul says, as a federal prosecutor, he would often argue whether to hold the defendant without bail ahead of a trial in a detention hearing.
That system focuses on what I think we all agree are the two critical factors, the dangerousness of the person who's charged with a crime and their risk of flight.
Republican lawmakers announced they would be willing to consider revising the Wisconsin Constitution to allow judges the ability to deny bail in order to protect the community. Kaul suggested putting more resources towards the district attorney's offices, the circuit court system, as well as the public defenders to help with an increasing caseload. Reporting for the I-Team, I'm Sean Gallagher.